respondent, who is the applicant in that application, that I recuse myself from further conduct on application, but who is respondent in this application is the Director of Criminal Investigations, DCI, Ms. Ivry Nonunga, working for the Office of Director of Public Prosecutions. The first respondent, who is the applicant, is represented, and Kevin Oganda. No formal application was filed for my recusal for further conduct of the matter, and this therefore, as it may, I will consider the oral submissions made by the parties and make a hearing for the first respondent. The submission is that I should apply wisdom, and wisdom means courage to walk away and let another judicial officer handle this matter. That I am biased, that I have handled a matter of a similar nature, and the outcome in this case is therefore predetermined. That the court has made a definite decision and the mind is already set. The second respondent stated that he agreed with counsel for the first respondent that this case go to another court, that he had lost faith in this court after delivering a ruling stating that this court has jurisdiction. Adjoined in this case is a third, a fourth, and a fifth respondents who indicated that they had faith in me to render justice and that I should continue handling the matter, that I have what it takes to handle this case, I am competent, and we should proceed. The victim family is represented by Mr. Apollo Boyer, who submitted that in an application for recusal, the party seeking a route, such a route, the victim family is represented by Mr. Apollo Boyer, who submitted that in an application for recusal, the party seeking such a route must establish the usually high standards for the basis of such an application. This is because it impugns into the integrity of the judicial officer being asked to recuse himself or herself. And this is because a judicial officer dispenses justice without fear or favor, being the oath judicial officer takes once they take up that job. That for apprehension of bias to arise, there must be factual foundations, and if factual foundation is wanting, then the application falls flat. And on the part of the victim family, they do not see any bias, and an application for recusal must be declined. In response, the applicant, the state, who is now the respondent in that application, opposed application by the first and second respondents that I should recuse myself from further conduct of this case, and relied on Article 159 of the Constitution that deals with judicial authority. That judicial authority is derived from the people, and it is exercised by courts and tribunals, and that justice should be done to all, irrespective of status. Justice shall not be delayed, and the purpose and principle of the Constitution shall be promoted and defended by the court. They also cited Article 160 of the Constitution, which deals with independence of the judiciary, and imputes that the person exercising judicial authority shall not be subject to control of any person or authority. The applicant further submitted that bias, as alleged by the first and second respondents, has not been articulated, all documented by way of an affidavit or application, rendering the same as mere allegations without any footing. And as a judicial officer and under doctrine of necessity and doctrine of duty to sit, I should proceed and handle the matter with expedition. They finally concluded and stated that I have given all parties equal opportunity to canvass their preliminary application, that proceedings have been open to all, physically and virtually, and the respondents have been aware of the proceedings, and first and second respondents have also participated in the same. On their part, they have complied, and in the interest of justice, I have acted so, and bias has not been demonstrated or articulated by the first and second respondents, and therefore the state opposed the application for recusal. The Judicial Service Code of Conduct and Ethics, Regulation 2020, at Regulation 47, 1D, and 3AB, it reads as follows, and I quote, 1. a judicial officer may recuse himself or herself in any proceedings in which his or her impartiality might reasonably be questioned, where the judicial officer, B, has actual bias or prejudice concerning a party. 3, a judicial officer may not recuse himself or herself if A, no other judicial officer can deal with the case, or B, because of urgent circumstances, failure to act could lead to a serious miscarriage of justice. I have duly read and considered all the authorities that were cited and referenced by the counsel appearing for the parties. I have looked at the case of Lawal versus Judicial Service Commission and another. Okoit was the interested party. International Commission of Jurists and another was the amicus curiae, and it was civil appeal, application number 1 of 2016, reported in 2016, case what the Court of Appeal found, and appraised also was one of the duties of the judges so to uphold. What flows from that authority I've cited is that the other persons fully aware of this case, apart from the first and second respondents, are the enjoined third, fourth, and fifth respondents. And as such, the third, fourth, and fifth respondents meet the threshold set out in that test, and I quote, reasonable, fair-minded, and informed members of the public of all the circumstances of this case. And the question I ask is, from the assessment of third, fourth, and fifth respondents, as reasonable, fair-minded, and informed members of all the facts and circumstances of this case, find me biased? And the answer is no. The victim's family, who equally are reasonable, fair-minded, were informed members of the public of the facts and circumstances of this case. Do they consider me biased? The answer is no. Does the state, being well informed of all the facts and circumstances of this case, consider me biased? The answer is no. It therefore cannot be that only the first respondent sees bias. It cannot be that he is the only one apprehensive that he will not get justice in this court. And while the second respondent stated that he lost faith in me after delivering a ruling stating that this court has territorial jurisdiction to entertain this matter, he never cited in clear terms that I am biased. I cannot assume he alleged that I am biased by so determining. I cannot be left guessing what losing faith in me meant. Bias should be obvious to all the parties, and especially those on the same side. Alleging that I handled a similar matter and so the outcome is already premeditated, to me is outrageous. Arguing that simply because a court has handled a certain matter, it will give a similar finding is the most feeble, flimsy, and inadequate argument of all. This is because a proper court only makes a finding upon hearing all the parties and considering any mitigating circumstances that may be offered. Otherwise, if outcome is predetermined, there would be no need to approach court for orders and remedies. And considering all the submissions made by all the parties and the referenced case law, I find that the first respondent did not specifically articulate and establish any ground of bias against me. And the upshot is that the application by the first and second respondents that I recuse myself from further conduct of this case lacks merit and is dismissed. So I think we move to the application by the state. Now that it has not been I don't know who's proceeding.
If you wish, hakuna shida. So we proceed? Okay. 4 matters that other Kenyans are still, of course, waiting to be served. Should we maybe then get timelines as to how we'll proceed? Because if we don't do it, maybe we can get time indications. so that we maintain that and proceed accordingly.
On our part, we'll take the most. All of us will not take more than 15 minutes. We'll ask critical questions. Totality 1 hour, 20 minutes. Let it be half-half. The state has half, we have half.
The second desk college also. That's
30 minutes at most to us.
Your Honor, just firstly, before I embark on my submissions, even though I was not party to the proceedings of the 8th of May last week, I, however, learned of the same remotely through media. Your Honor, this is important because as a member of the bar and a member of good standing, Section 55 of the Advocates Act behoves me to conduct myself as an officer of the court, and so that applies to defense counsel and all counsels appearing before these courts. And we therefore want it to go on record for the part of the state that on behalf of the good and honorable profession that this practice is, we wish to register our apologies in the manner in which this honorable court was addressed during those proceedings. That is important to maintain the honor and dignity of this profession. We do sincerely apologize on behalf of the profession. But now, importantly, moving forward to the application dated 8th of May, and supported, application dated 8th of May and supported by the affidavit of one of the gallant officers in this matter, Inspector Oliver Nabone, firstly, we wish to rely on the grounds as affirmed thereon, in as far as seeking 30 days custodial orders is concerned. In as far as seeking orders for 30 days custodial orders is concerned, save that we'll be calling the court, because we come in good faith, because we come in good faith, as was discussed by the High Court in the Oscar Sudi case, because we come in good faith, we'll be asking this court, should it allow our application to factor in the number of days already spent by the respondents in lawful custody. In lawful custody for circumstances that were beyond our control as the applicants. Your Honor, to start with the reason as to why we do seek further custodial orders as against the first and second respondent, Your Honor, it has already been deponed by the inspector that the first respondent has already been linked to the persons who are actively tracking the movement of the deceased, to the persons that were actually tracking the movements of the deceased on the very date he was killed. Whilst a pistol was recovered upon the arrest of the second respondent before court. All these matters are deponed in the affidavit. Your Honor, already inquiries with the firearms examiner have been able to firmly link this very pistol to the offense under investigation. Your Honor, it is therefore our argument that there could not be any better reason that will oust our application to have these two suspects held in custody for further investigations. Your Honor, further reason is that an American poet which has now gained notoriety again in legal parlance, that this was said in the early 19th century, and this poet did not know that it will come and have relevance in our times. That, Your Honor, when something looks like a duck, swims like a duck, and it quacks like a duck. Charlene can finish that for me. I know she's just from school the other day. It's most probably, Your Honor, is a duck. What Oliver is telling this court, that the two persons we have before this court, on a balance of probabilities, are most very likely, Your Honor, to be the persons who either pulled the trigger or acted in concert to the ones who pulled the trigger. We urge Your Honor to grant us time to complete investigations. Should we finish that before the 30 days, or as the court will direct, we'll come back with a report. Because we are officers of the court, and we do this in good faith, and even with the interests of the respondents at heart. We therefore humbly pray that the court does grant us this application. That's all, Your Honor.
First respondent have a role to play during the analyzing of ballistics.
He has no part to play.
Thank you. That is all. And during the conduct of it, what was his conduct during arrest? Did he resist arrest? It's a yes or no answer. Did he resist arrest at the time you were arresting him?
He had fled.
You have not answered my question. Did he resist arrest?
Your Honor, he had fled.
He had fled.
From Nairobi.
Is the fleeing of the first respondents deponed in your affidavit, or is it not a legal requirement?
I've deponed here that he was arrested in Nakuru, but for now we've established that his place of abode is in Nairobi.
I've not asked you about his place of abode. Did he exercise any resistance at the point of arrest? You're an officer. This is not your first case. Answer the question. If you're not aware, leave it alone.
And you're not aware, it's also an answer. If you're not present, you're not aware, it's also an answer.
Thank you, Your Honor.
You respond what is within your
Your Honor, he did not resist arrest.
He did not resist arrest. Is his issue of being a flight risk deponed anywhere in your affidavit?
I have not deponed him.
Thank you. That is all, Your Honor.
Am I cross-examined?
That particular article says that the suspect can be released, Your Honor, pending a charge. If the prosecution are not ready, I read the whole of it, yes. But unless, of the other part, unless there are compelling reasons not to be released. Your Honor, in my view, the prosecution has not met that threshold. The philosophy of whereby the prosecution are talking about the balance of probability. Your Honor, just to speed up, Section 36A of the CPC, in as much as it allows.
And Article 49 is so clear that once the state has arrested somebody, or somebody has been brought before a court, be it under Article 49H or under Article 49G. Yes. Yes. Yes.
You have said once they fail to do so,
once they fail to do so, we come to you under Article 22, 23, and we come under Article 165, whereby we ask you to now realize that our fundamental rights are being curtailed. Now you have been told the first respondent was arrested. You're being told by the officer that it was in Nakuru. But you're not being told whether where he was found, where and when it was found, was not a place that he can be, or whether he's allowed to be there. If it's a place he's hiding, they needed to tell you he was hiding where. They look for him and find him in a place and he's there. They do not tell you when did he abscond, from which place, when did he abscond, so that you know actually he did abscond. But But they want to tell you that he is a member of a gang, or a, what did he say? An organized gang, okay, criminal gang. That is what it will be eventually. You're not being told he entered a gang, when, where, and how does this gang go by which name, or how does it operate, or where the base is, or where it operates from. Who is he in that gang? So this is why I told you, Your Honor, you're given stories. It is the same officer who has come here and told you they don't know anything about his phone, they're looking for it, but swears in an affidavit that there is communication on his phone gadget with other people. How did he get this information? Yet he's telling you, we have not investigated his phone, we have not seen anything else, but they tell you there is communication. When I tell you, Your Honor, this is the story, please believe me. You are being told that he is a person who would want to abscond. And you're being told by counsel that it is in human nature. Is it also in human nature that I'd want to defend myself? Yes.
The court taken.
Yes, Your Honor?
He's saying the Supreme Court of Canada is the one that taken.
Yes.
Quoting the ones of the judges.
Okay. But the thing is, that is what he wants to put to you, to believe that it is in nature that he'd want to do so. Not him, the prosecutor, not the judges, but this, that is what they want to tell you, that his nature would be able to do that. But is it not so, also not his nature to want and defend, to defend himself and to clear his name? How is that a convincing reason? That is the question you need to ask yourself here. How is it a convincing reason? How is it compelling? But yet they tell you he probably would want. And this is why you need to look into the authority of Richard David Alden versus Republic High Court case.
Richard?
David Alden versus Republic. It was a High Court criminal case number, I think, 48 of 2014. It's a matter I was the advocate in that matter. Just yes. It's you know, in this file that you have, we had handed it earlier on.
Yeah, we give those authorities.
Yes, we gave the authorities, the two authorities that are there.
I'll get the citation.
Yes.
Richard David Alden, that was Republic.
Yes, Your Honor. In that case.
You have 3 minutes to find minutes. Because now our one that is looking back, so that we go to the second response. 3 minutes to find minutes. Our time will have been exhausted, and we have to get the second response.
You see, Your Honor, now.
We have extended a lot of time, so we give you 3 more minutes. Because we have even eaten into the second response time.
Your Honor, in that authority, I tend to think every time I speak, it's like I'm sidetracked. I have to think what I was saying. In that authority of Richard Alden versus Republic, what did the court say? So as to cure this problem of imaginations and all those things, the court said, and this was Justice Lesit, as she then was, for you to say that somebody will abscond or may abscond, you must place material before the court. It no longer was an issue of probabilities. The court said, place material. It has to be a fact. You must show that he has prepared to abscond, maybe bought tickets or made plans. Those are the exact words used in that authority. You must show. Even in the case of Dwight Sagarai, that is the same position.
Yes, sir. Right.
Sagarai versus Republic. It is also the authority that we have given. You must place material. Justice Correll also said that. So that we cannot have imaginations that he might or he may and then trample on his fundamental rights because somebody imagined. Such that we are saying, grant this person bond, he will be able to abide, he will be able to give conditions, because one of the things that the court also said is you do not only say that he'll abscond, you give conditions to ensure that he stays. They have not shown that he has refused to cooperate. They are now giving you stories from the door. He is a student. He is a student of the university. Please give him bond. I think I'm frustrated.
Law operates on principles. Matters such as the one that is before court, the court must make a determination either way based on principles that have been set in law. Most certainly flowing from precedents that have been established by superior courts and applied by this court. I shared two authorities which I will be making reference to. The Michael Rotich decision I shared with the court and my seniors counsel for the prosecution, and that of Oscar Sudi Kipchumba. Michael Rotich, Your Honor. I shared a copy of the authority with the court. Versus Republic, decided by my Lord Justice Luka Kimaru. And the second, the case of Oscar Sudi Kipchumba versus the Republic, sued as the National Cohesion and Integration Commission. Decided by my Lord Justice Professor Joel Ngugi. Very quickly, Your Honor, permit me to direct the attention of the court, particularly to paragraph 24 of the Oscar Sudi Kipchumba decision, where my Lord established two principles that this court should look at in deciding a matter such as this. First, this court is urged, which we urge, that the court should employ the less restrictive measure when it comes to its decision aimed at limiting the rights and fundamental freedoms of the respondents. So much so that the court should ask itself, in balancing the quadruple rights, those of the victims represented by my senior, the former CEO of the LSK, Apollo Mboya, the rights of the public represented by my seniors counsels for the prosecution, the rights of the respondent, and those of the public interest. The court should ponder how best can we assist the investigators in doing their job without necessarily frustrating or otherwise unreasonably limiting the rights of the respondent. Your Honor, it has been said the respondent is a student. The first respondent is a student, supposed to be registering for his semester on Thursday. This essentially means that if you are to permit the application of the DPP in the manner or the form in which it has been presented to you, this court will, in other words, unreasonably limit his right to access education. Your Honor, it is therefore needful for the court to consider declining the invitation as invited by the DPP, if not for anything, to allow the respondent to be in school come the 15th day of May 2025. He is a law-abiding citizen and he can adhere to any prescriptions as made by the court to ensure that we assist the investigators in this matter. Second principle, Your Honor. On the second principle, Your Honor, the court is to ask itself whether the application that lies before court has been made in good faith. Your Honor, my seniors have gone a long way to demonstrating that the application that lies before court has just been made routinely without any justifiable cause or reason. This is what we do in this country nowadays. We arrest people knowing too well about the prescription set under Article 49 of the Constitution, we rush them to court. So that we can ask the court, without any justifiable reason or cause, to continue detaining a suspect for whatever reason that there is, Your Honor. In another attempt, Your Honor, to demonstrate the bad faith in which this application has been made, Your Honor, on the face of the application, the notice of motion application, the application is made under Section 36A of the CPC, Cap 75 laws of Kenya. The relief sought, and Your Honor, I will request that the court takes attention or keen note of this. The court has been asked under Prayer 2 to grant the investigators a period of 30 working days Your Honor, I am very persuaded that the drafter of this application knew too well the provisions of Section 36A7, sorry. Your Honor, Section 36A7 requires of the court that when an application such as the one that lies
for 30 working days, but to consider the possibility of custody to enable investigations to start.
Your Honor, I've heard the state if the ballistics have confirmed so. Connected to the murder case, with the case before the court. And if it's so, Your Honor, why again 30 working days? I pray to this honorable court, Your Honor, to grant at least, if it's mere 5 days, Your Honor. And again, I've heard the state saying that we were directly connected, or we know each other Sincerely speaking, before the court, Your Honor, I've met the first respondent here in court. My phone or my mobile phone was seized upon my arrest, and I can confirm so. I've never seen the first respondent. We've never talked. This is my first time. My first time when we were in court is when we met here.
Your phone was one or no?
One. And they can confirm it, Your Honor. I've never had any contact. I've never seen the person in court. We only met here in court. And that's all, Your Honor.
That has been done, then why 30 days?
Okay.
Yes.
Perfect.
If that is already established, then why that?
This is
Maybe we can
a
start
valid,
with answering that question.
yeah, it's a valid question. I'll start with that, Your Honor. Thank you. So, Your Honor, you know it is said that the dead tell no tales. The dead tell no tales. Honorable Were is not here to give us an account, bit by bit of what happened. It is only through investigative procedures that, as per the IO, we may require these 30 working days, and as I state, we are convinced of the same. It is only through these investigative procedures that now Honorable Were will be able now to tell us what really transpired. His voice will speak through these internal investigations. As regards to the pertinent issue raised by the second respondent, Your Honor, yes, the murder weapon has been connected to the recovery before court. That's the pistol. But Your Honor, from an investigative standpoint, it does not then mean that investigations now have to end there. For every criminal enterprise, as we do insist, they don't have to have any name, they don't have to go by any grouping, like we have known them, the criminal groups know. A criminal enterprise can only be brought together for the purposes of the execution of a particular act. They don't need to know each other. That is not how criminal enterprises operate. So that even if we have found second respondent linked to that murder weapon, investigations need to tell us who sent him. Was he acting alone or in concert? We believe he was acting in concert with others, not before court and others before court. And it is for this reason, Your Honor, we're saying that even though we have some pieces of this jigsaw puzzle, we are yet to be there. Hence the requirement of these 30 days to enable us now paint the whole picture of the trial court in the fullness of time. You know, now to start with and to respond to the views or position taken by counsels.
I thought he said the replying affidavit.
But I don't want to, because I know this court is engaged with other matters. Your Honor, firstly, it has been said that the prosecution has treated this court to philosophy, and therefore this philosophy was being downplayed. I would say that is a sorry remark to make in litigation. The law as we practice it, the law as we know it, is based on legal underpinnings, some dating back to the 15th century. The likes of Thomas Hobbes, John Locke, Memdo. It is a practice based on philosophical backgrounds, and cannot hurry away from that if we are to be good litigators. Your Honor, it has been suggested that subjecting these respondents to further custodial measures will be intruding into their rights to bail and bond. But, Your Honor, it is our position that, based with the circumstances that Inspector Nabone is faced with, any prudent officer, while faced with such circumstances with regard to evidence that is coming in from various quarters, from various respondents, suspects, that Oliver has been able to recover what is thought and believed through evidence to be the murder weapon. Your Honor, the least restrictive measures whilst faced with these circumstances is to do what we are doing now, to apply for this continued detention, legal continued detention of these suspects. And Your Honor, it is a fallacy to try and suggest that Article 41G is an absolute right. It is not. 49(1)G is not an absolute right, Your Honor. It is fallacious, therefore, to say that when we attempt to limit this right, the state is exceeding its mandate, or rather its powers. Your Honor, Parliament, in its wisdom, enacted Section 36A of the Criminal Procedure Code to give further effect to that Article 49. So that the legislatures envisage a situation or a scenario whereby it may be legal, and in fact it is legal, where circumstances allow, like this one, to hold a suspect past the 24 hours, and Your Honor, not even for 1 day, more, not even 90 days, but actually the Terrorism Act allows us to hold for 360 days. 360 days when we have reason. So that there is nothing out of the ordinary. There is no bad faith. And Your Honor, when I started, I did indicate that we come in good faith. Earlier on in my submission, I said we come.
We bring affidavit to endorse our file.
Yes,
Part
yes.
of your submission.
Yes, we filed an affidavit. I don't know if the court has it.
Considered the submissions made by all the parties and the cited and referenced authorities. It is clear that the matter under investigations involve murder of Kasipul Member of Parliament through shooting and killing. From the submissions, it is clear that this was a well-organized criminal activity that was well executed. And in such organization, several individuals have been linked, and it is important that investigators are granted sufficient time to thoroughly investigate the matter and sort out the wheat and chaff so that proper individuals involved can be charged appropriately. The nature of this case, therefore, demands that the suspects brought before court, including the first and second respondents, be remanded in custody as investigations continue. It is also key to note that, based on the public interest the case has elicited and the different emotions the murder has elicited, any person arraigned in court as a suspect in this murder case be detained in custody for their own safety as tempers cool down. Nothing has been tabled in evidence to show and confirm that the first respondent is a university student, and as it stands, those remains but unsubstantiated allegations. I am convinced that the state has brought the application in good faith, hence they have urged court to consider the period the respondents have spent in custody. In the upshot, considering all the circumstances of this case, I find merit in the application by the applicant, and the order sought to detain the first respondent at Langata Police Station and the second respondent at Gigiri Police Station, respectively, is hereby allowed, but for a period of 23 calendar days in the first instance. Prayer number 3, the one for exploitation of mobile phones and SIM cards, has been allowed as prayed. So we can agree mention after that date.
Much.
In this matter, because we take the progression of the case as it moves. Yes. I don't know what I see, and you wanted to say something. You want to say something? I don't know where to start.
Yeah, it's overtaken now because I was like, ni maneno ya pingu, lakini nimekubaliana nao watanitoa.
Okay.
Another consultation. We shall be requesting the court kindly to change to Capitol Hill Police Station.
Do you have another suspect there? Because what I'm informed is that there is no suspect. I think on the first day, when you're not there, they are not putting 2 suspects in one station. And I think I demanded one of the suspects at Capitol Hill on the 1. And I'm told they are not putting 2 in the same station. And I think, if I recall, the suspect was brought yesterday and the benefit of going to Kasarani, because the one went in Kasarani, I changed him from Kasarani to Kideleshwa. So if there is another suspect, they are not putting them in one station. There is a suspect already in Capitol Hill.
Well, we will not fight harder on that. We can agree either to the money. These lawyers, 99% are Milimani practitioners. We want to be where we are able to access our land.
Okay.
That's the only reason that it is us requesting to be given a